Okay, let's go on the record on cause number DC 2113889, Dobbins v. Uber Technologies, Inc. Counsel, make your appearances.
Brett Stanley on behalf of Jermaine Dobbins.
Abby Bohenick on behalf of Uber Technologies.
All right, this is a new one for me. Is this going to be something we see a lot of coming up? This is a dispute, I guess, between Uber and one of its drivers.
Yes, Judge, we represent many drivers in Texas, and we are pursuing these claims. They're wage cases. For our claims are failure to pay appropriate minimum wage based on time driven and miles driven. We expect that there will be more hearings like this to appoint the arbitrator. There's a provision in the agreement that allows for us to move to a court of competent jurisdiction to appoint an arbitrator in the event that the parties cannot agree. And so that's what we're doing here. We have filed some of these already in Dallas County that have been heard by other judges. You got luck of the draw on this one, and so that's why we're here in front of you today.
Okay.
One thing that I'll note in our filings and on the first page, we said that the driver was from Austin, Texas, and that's a typo. The driver did drive in Dallas, Texas, and if you look to Exhibit C, that shows his last drive, which is what controls for the court of competent jurisdiction. We have to bring this hearing before a court within 45 miles of the last drive executed by the driver. And so that's why we're here before you today. May I proceed, or do you have any other questions at the top?
Nope, go ahead.
Okay, great. So Exhibit B has the operable agreement between the parties. And if you look to section 13.3, that has the provisions that allow us to come to you, right? Specifically 13.3G says if for any reason the parties cannot agree to an arbitrator or JAMS will not administer the arbitration, either party may apply to a court of competent jurisdiction with authority over the location where the arbitration will be conducted for an appointment of a neutral arbitrator. And that's what we ask you to do today, Judge. This case has not been commenced yet because we need an arbitrator to commence it to go forward. Once we get an arbitrator, we will file the commencement fee, which under the contract requires us to do to start the arbitration. And so that's what we ask. If you want to look at some of the other provisions in 13.3 that I think are important, 13.3A says that if there's a conflict between JAMS rules and the arbitration provision will govern.
Excuse me.
Yes, sorry. I'll slow it down for you, Ms. Walker. So 13.3 just says that the contract itself should be taken above JAMS. Is something we see often in contracts between two parties. And so we did not supply you with names. The names that Uber has supplied you with, we don't agree with, and we haven't supplied you with.
So let me ask you this: does it have to be through JAMS, or can it be someone else?
The parties historically have, in Texas at least, have agreed to operate under the JAMS procedures, and have had arbitrators that weren't specifically part of JAMS, and so that's been okay. So we don't necessarily have to go through JAMS. The contract says JAMS procedures will apply. And so judges are free to appoint a neutral arbitrator under 13.3G as they see fit. It doesn't say anything in that provision that requires you to pick a JAMS arbitrator. And so we didn't provide you with names. If you would like a set of names, we can give you those, but I'm sure you know arbitrators that you can choose as the agreement allows you to choose them.
Judge, if I may, I
Sure.
may have a way that we can short circuit this. As Mr. Stanley said, they filed petitions on behalf of other claimants in front of other judges. And on Friday, Judge Tillery appointed Judge Kevin Bernard Wiggins in that case. Previously, we have been assigning 2 claimants to every arbitrator. And so Uber would be fine with having Judge Wiggins serve as the arbitrator in this case as well.
As a response, Judge, it's up to you, is what I would say. I'm sure that Mr. Wiggins is a qualified arbitrator, but you also have the ability to choose whomever you would like. And if you have somebody else in mind that you think would be,
I like Judge Wiggins. I know Judge Wiggins. I don't have a problem with him. I was The person I had thought of when I read this was Karen Washington. She's very experienced employment law lawyer who does a lot of arbitrations, but I don't have a problem with Judge Wiggins either.
Claimant does not object to Judge Wiggins.
Uber's agreeable to that as well, Judge.
Okay, let's do Judge Wiggins. I don't see an order in the file, so
We will get
do
one
you guys
over to
wanna-
you today, Judge.
you'll forward me an order today. Okay, great. Is that it? Is there anything else you need from me at this point?
Not from the plaintiff, Judge.
Not from the defendant.
Typically, the order is in other arbitrations. We typically get an order ordering the case to arbitration. I don't usually appoint arbitrators, but I can obviously will in this case. Is there anything in the order that's going to go ahead and close this case, or at least abate this case while you go through arbitration? Do you have that in the order?
We will include something in the order that closes the case. This is the only matter before you at this time on this case.
Okay. Sounds good. You guys just get me an order as soon as you can, and we'll get this taken care of.
Thank you, Judge.
All right, great.
Dismissed.
Thanks
All
so
right.
much, Judge.
You have a great day.
All right, you too. Bye.
Bye-bye. All right.
Judge Hoffman.
Hello. How are you?
Doing good. Good to see you again.
Good to see you. I think our next hearing is on the Owen case versus Garden Design. Anyone here on that case?
Yes, Your Honor.
Yes, Your Honor. This is Christiane Edlund. I'm here for the plaintiff, Richard Owen.
Your Honor, I'm William Newman. I'm here for the respondents. Before we get started, I should ask, we filed objections to this hearing, and I don't know if they would have made it to the court yet. I emailed it to Ms. Pinson and hope she could get it to the court in time for the hearing. I don't know if it's made it there yet, but there was never a conference on this particular motion in this particular hearing. And in fact, I've agreed with nearly everything that was sought by the plaintiffs, and I think there are only 2 objections I'm standing on, and everything else I've provided everything we have.
Your Honor, this is my motion. I think I'd like to have my, I'd like to go first in this matter.
I guess the real issue is that if you haven't conferenced, then you need to conference. Have you conferenced or not?
I have conferenced extensively over months with Mr. Newman.
And I've agreed.
Okay, so he's agreed. Okay, I've been asking, this discovery was served last November 2020, and I have been asking, one of the defendants that he represents, there was no discovery responses at all served.
That turned out to be false.
The other one, he said will produce on all the responses and produced 0 documents. I've been trying to get these documents for over 7 months. I've emailed him, I've called him, I've talked to him in person. We had a motion to compel hearing set earlier this year, I think in September 20th. September 16th, the morning before another motion that I had in a different court on the exact same issue, he finally called me 30 minutes before the hearing and said, I please call down the hearing. I promise I'll produce these documents. Let's get a Rule 11 in place to get these documents responded to for both cases. Excuse me. I agreed to the Rule 11. I called down the hearing, and I called down the hearing in your court as well, based on the Rule 11 agreement, that he would produce the documents by September 30th. He never produced the documents. So then October 1st, I emailed him and said, you have breached your Rule 11 agreement. I'm going to have to file a motion to compel. He said, please, I'm busy in trial. I will get these documents to you over the weekend. I waited over the weekend. He still did not get the documents to me. I think he finally served these documents on Friday. I haven't even had a chance to look at them.
Well, I'm sorry, can I respond?
Sure.
Yeah, I mean, that's roughly accurate as plaintiff's counsel, and I don't want to go into my personal problems, but I was out for about 2 months for surgery, and that led to some problems getting things in a lot of cases. I've been behind. I've been trying to catch up. I agreed to produce things by the end of September, only to come to an agreement. And as it turns out, I was just swamped with trial prep. And as she said, then I said, give me through the weekend. Unfortunately, over that weekend and during the following week, some additional family health emergencies that took me away from work. And then once I got back, I've spent the last week trying to get current on discovery in 2 cases, and they're unrelated cases, but in 2 cases with Ms. Edlin's firm. And I think I'm now giving them everything. As it turns out, they already had all of it. They had it either from me or from other parties. And there's nothing else I have to give. I'll tell you what the only 2 bones of contention are that I'm standing on is she wanted statements to insurers. That the only statement is the claim made to the insurer, and that's already after litigation is anticipated, and that's on its face investigation and work product. And the other one is employee personnel files. This is essentially a slip and fall. It's a premises liability case. There's the allegations there was a slippery condition on a sidewalk in a private gated community. The plaintiff is one of the residents, was riding his bike, claims to have slipped on this dangerous condition. And I think there's only one.
Mr. Newman, let me ask you this. Did you timely file objections to this discovery?
Actually, we did. I think, as Ms. Edlin said, there was never anything filed. I think Christiane, I later sent you the ones that were file stamped and showed you it had been done. But even
no, they were not file stamped and they were not served. And the document you sent me clearly stated, and I told you this, clearly stated that they were not served. They were never served on us, and they didn't include any. It didn't include any documentation anyway.
It had an e-service, proof of service attached to it.
No, it did not. It did not.
Regardless, the only 2 issues, and that was for one of the 2 defendants, and the other one, they're related defendants. But
okay, those are not. Those are not the only 2 issues. You served 0 discovery responses.
But I have
zero discovery responses.
Guys, you're yelling over each other at this point.
I have given her.
Wait, Mr.
Your
Newman,
Honor.
wait. One at a time so the court reporter can get this down. So let me ask some questions here, and you guys don't interrupt me.
Sorry, are we on the record? I did not know we were on the record.
Oh yeah, we're not even on the record, so I guess you can yell at each other because no one has to go on the record. So, do you want to go on the record, Miss Edlin?
No, Your Honor, I don't think we need to go on the record.
Okay.
But I would like to address some of the things that he said.
Okay. Let me ask this first, Mr. Newman. So you say that you filed. This is the fundamental issue to me at this point is, did you file timely objections to any of this discovery?
I believe so. I don't have it in front of me to prove it. I believe we did. I know we did on behalf of one of the 2 defendants. The other one, I'm less sure. But those are the only 2 issues. And one of those is core work product. It doesn't require an objection. And the other one is personal privacy on documents that couldn't be less relevant to the issues in this case.
Ms. Edlin, do you agree that he filed one of these timely and one of the objections untimely?
Your Honor, he represents 2 defendants. One is Tribute, which is the HOA where this happened. And the other is RTI, which is the management company that manages the property for the HOA. Tribute, there was 0 discovery responses filed, 0. RTI, he served discovery responses, but they all said, will produce for all the responses.
Were there objections filed with that or just?
With RTI, yes. With Tribute, there was no response at all.
And they're identical discovery, by the way.
So let me ask this. So did he object to the production of the personnel files for RTI?
I believe so, but I disagree that there's only that those are the only two issues that I'm filing this motion to compel over. The motion to compel is over all of the discovery requests because nothing was responded to on one, and on the other, he said will produce, but no documents were ever produced. It's not a matter of two specific issues. It's never been a matter of two specific issues.
So assuming that's correct for, I guess it was the homeowners association that did not file a timely response, then all objections are waived. All production will be done within 2 weeks. For those, for RTI, where there was timely objections, I can go through the objections individually if you want me to, or I can just order him to produce all the documents subject to objections, and he can then withhold documents, notify you what he's withholding within 2 weeks. What do you prefer, Ms. Edlin?
Well, Your Honor, we had a Rule 11 agreement in place, and he had agreed in the Rule 11 agreement to respond to everything without objection, subject to any attorney-client privilege.
Except for those two issues.
And Your Honor, in addition, I'm asking for sanctions because this is, first of all, been going on for over 7 months. I've been trying to get these documents.
Let me ask you this. When was the Rule 11 filed?
I haven't filed it yet. We have a Rule 11 agreement in writing that was done in writing on September 16th. Okay. And I can file it, but he's breached the Rule 11 agreement.
I mean, the Rule 11 agreement's not enforceable until it's filed, so. And I can't.
Yeah, I can file it today, but the bigger issue is the lack of responses to discovery from this particular defendant has caused other problems and issues with the other defendants. There's like 7 defendants in this case. It's not a simple slip and fall. This was a path where algae had accumulated because of overrun of water. And so there's irrigation problems, there's landscaping problems, there's experts involved with landscaping. It's caused a domino effect of not being able to get experts designated properly, get documents filed properly because I don't have the documents from the defendant. It's caused major problems.
Ms. Edlin, I'm trying to get that resolved for you. It's just without a rule. I don't know what the Rule 11 says. I'll enforce the Rule 11, but since it wasn't filed, I can't enforce it until it's been filed. And so I don't disagree with anything that you're saying. I just have an incomplete picture because things haven't been filed.
I can file it, but my request would be, and what the Rule 11 said is that both of these defendants would respond to discovery in full without objection.
Can you share screen the Rule 11 so I can see it?
It's in an email. I'll have to look at it. Let me see.
It's a series of emails, Your Honor, and I agreed to produce everything by, I think, the 1st of this month, or last month rather. And then as I discussed with Mrs. Edlin, that I ran into some problems with and asked for an extra week roughly. And then after that, unfortunately, I had some family health issues that I was in the hospital, my wife for a week, and then, and it was a long story, but I was in the ER for myself at the end of that for a day. And then I've, since that time, in the last week or so, I've been trying to get up to date on all the discovery in both these unrelated cases with our firm. And
so Mr. Newman, I respect that, and I want to give you an opportunity to kind of make it right. And so I'm not going to award sanctions right now, but I don't really know the history between the two of you. I don't know what the Rule 11 says. And so what my inclination is to give you 2 weeks to kind of make it right. Unfortunately, if you didn't file timely responses, you waived them. That includes any privacy complaints that you may have about producing employee files. They're going to have to be produced if you waive the objections. And so, but it would be helpful to know what's in the Rule 11 agreement. Rule 11 agreements have to be filed to be enforceable. And so I don't know what they say or what the agreement is, but if you agreed to produce things without objection, then everything for the if that's the case. I don't know if it is.
Well, save for those two areas.
I'm sorry.
One's core work product, and I understand. I mean, I don't think there are any employees of the community, so I don't think that's an issue. But okay.
I mean, there's consequences for not filing timely. So the consequences that you lose your objections. So Ms. Edlin, have you been able to find and you're welcome to share screen.
Yes, I can. Let me share screen. We've had a series of emails and it's this case and another case with the exact same problem that I've been having. So they're kind of intermingled, but let me share screen what I have.
Okay. Is there an actual letter that was signed, like a Rule 11 letter, or is it just email?
It was just email. I relied on his word, which is probably dumb, but it was an email. And so for this is, can y'all see this? I don't know if y'all can see the email.
Yeah, we can.
So this is a follow-up. There was a prior email where he agreed to produce all this by September 30th. But it was in a different case. So then for this case, he sent this follow-up where he said he was going to respond to interrogatories in full. And then he's got basically responding to everything except for work products.
Okay. So the interrogatories will be answered in full, and then he's withheld certain for these requests for production. He's, I guess, maintained certain objections. It looks like.
I mean, basically, the only reservation or objection was if it's work product.
Is this can you go down a little bit? So is there anything else to this?
Well, there's series of emails, but so as far as the Rule 11, there's another email prior to this where in the different case, which is with Anna Kemp, we agreed to September 30th. And I can try to see if I can.
Anyway, the upshot is I'm trying to be cooperative. I'm trying to provide everything we're supposed to provide. And I think I have now. And as it turns out, there are no documents that I have access to that she didn't already have, either from me or from another defendant.
Well, that's the problem is I don't know that. And that's not that's not true because they have documents that only are in their possession that I needed for my expert to review and make certain determinations. And we didn't have privilege to those documents. And now it's too late because statute has been blown and certain defendants have been dismissed from the case. And it's caused a lot of problems because I couldn't get my expert to get a full analysis.
As far as I can tell, that's not true. They have all the documents. I'm trying to find out if there's anything else, and I'm talking to my clients. I don't believe there is. And number two, that's certainly not our fault that they couldn't get a certificate of merit on the defendant that's been dismissed. Ms. Edlin has told me that, well, you know, we don't know that this had to do with an architect, which again, this is a premises, you know, whatever. But an architect that designed the wall that allegedly caused the water problem. And they had the identity on the plans of the architect, and then she said, well, their expert didn't know if that's the ultimate architect, the original one. It's like, I think it is, and I don't have any way to show that it isn't. I don't understand why that wasn't enough to get a certificate of merit, but that's not my doing. I mean, that's just, you know, she already knew about it in time to file the lawsuit and couldn't get a certificate of merit. That's not my doing.
I couldn't get a certificate of merit because we didn't have any information about who the original architect was of the premises. And that was discovery that I had been asking for from these defendants, and they're the ones that have possession of it because they're the owner of the premises. And so they're the only ones who had ownership of documentation on who originally designed this particular area.
What they had were the plans for all the issues that they complain of, and it had the name of that architect. So I really don't understand that complaint, but that's neither here nor there. I don't think there is anything else, but if there is, I'll produce it and find it.
Him saying, well, I already have these documents from other people doesn't excuse him for not being able to serve discovery. I don't know what documents I do or do not have compared to what they have. And that's the whole point of discovery. And I've been asking for these documents for over 7 months. I've already filed, this is the second motion to compel we've had to file.
Well, and again, all of this comes back to, there's got to be a showing of relevance. And this case involves literally a slip and fall, and the allegations are premises liability. And for some reason, the plaintiff's attorneys want to turn it into a much more complex case, which I flat don't understand. It seems to me that they have a pretty clear, direct, and simple case that they can find clear defendants. I represent the homeowners association, which, as far as I can tell, is the owner and occupier, and the management company that basically is its agent. It doesn't do much, but it's the agent, on the ground for the homeowners association. I don't know why we need an architect. I don't know why we need a lot of other things. None of that's frankly relevant to the underlying issues of the case. None of it goes on a jury form at the ultimate trial. But at any rate, as far as I can tell, she has all the records that I have. I'm looking to see if there's any more, but I don't.
All right, so this is what we're going to do. I'm going to order all for the discovery that was not timely responded to. All documents are going to be produced within 2 weeks without objection. Failure to do so will result in a $10,000 sanction. For those that were objected to, subject to the Rule 11, those will be produced within 2 weeks, subject to objection. Failure to do so will result in a $10,000 fine or sanction. Ms. Edlin, go ahead and prepare a proposed order on that, and we will go from there. Thank you, guys.
Before you go, Judge, can I ask you one question on if there are any employees, and I don't think there are, but if there are, can I withhold personal tax and health information?
No.
Because those are non-parties, and I don't represent them.
If they were employees and they're in your care, custody, control, and you waived your objections, then they need to be produced.
All right.
Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Anything else, guys?
Just by the way, I don't want all these people in here either, but the other defendants have been adding responsible third parties and they've been making it complicated. I want it simple too, but it's not. So, but thank you, Your Honor.
And make sure you get me an order on that, Ms. Edlin. When you prepare the order, go ahead and say that the hearing was held at the beginning on November 1st, 2021. Don't say on this date. And make sure it includes all of the things I just discussed. Make sure you share a copy with Mr. Newman before you file it, and then email it to my court coordinator as well as e-file it, okay?
Okay, thank you,
All right.
Your Honor.
Thank you. Have a good day.
You too.
Okay, I think we have a couple of scheduling orders coming up, scheduling conferences coming up.
Yes, Your Honor. This is Mark Tarabi. How are you?
Good. How are you?
Doing well, thank you.
So we have Merched versus Farmers Texas County Mutual Insurance Company. Is that right?
Yes, Your Honor.
Okay, what's going on with this one?
Your Honor, we submitted a proposed scheduling order that was agreed by both parties. I don't believe we had got them actually like a signature from both parties, but it has been submitted with the certificate of conference indicating that plaintiff's counsel was on board with the proposed order.
When did you submit that?
I believe on the 27th. I'm looking at the copy that I've got in my file, and for some reason, I don't know, do they not file mark the proposed orders?
Let me just see.
Because I don't have a file stamp on it, but I think it was submitted on the 27th.
Can you see this, Mr. Tarabi?
Yes, sir.
I don't see a proposed order. Maybe I'm missing it.
All right, I will. Like I said, the one that I just pulled off of my system didn't have a stamp on it, which I thought was odd. And I was told that it was submitted on the 27th, but it doesn't look like it was. I will have to.
It's possible the clerks haven't processed it, but that would be really, really slow.
Yeah, that would be.
What they usually do within 24 hours of this is the beginning of the week. What is the trial date you guys agreed to?
The trial date that we went with was jury trial setting on May the 10th, 2022.
And is that a Tuesday?
I believe so. Yes, Your Honor. Let me check for sure.
Yep, it is.
Okay.
Okay, we'll go ahead and just reset it to that time. Hopefully, go ahead and maybe resubmit the scheduling order or
Yeah, I'll make
double
sure
check that it's been filed.
Yeah.
But we'll go ahead and set it on May 10th, 2022. Anything else today?
You know, Judge, if you got a second, we were on your docket in another matter for an agreed motion for judgment nunc pro tunc in a different matter. It got pushed because you guys were in trial, as I understood. So, and I don't know why we were on the hearing. I was trying to see if we could get this thing ruled on just by submission, since it was agreed by both parties.
Yeah, there was an issue with that. That's why I wanted to chat with you. Do you have the cost number on that?
I do. It's DC-20-01712.
Let me just look at it real quick. I typically will sign those if they're agreed to. So I kind of recall that there was an issue. If this is the one I'm remembering.
Yes, Your Honor. And the issue was, I believe the court signed the wrong proposed order. This was the one that got signed was the one that was submitted pre-trial by the plaintiff.
Okay.
We entered a Rule 11 agreement, and we resolved by agreement on the record, and the terms of that are reflected in the corrected order that's attached to the motion for judgment nunc pro tunc. And if the court, I don't think that I attached it, which I should have, but I actually, your court reporter did send me a transcript of the Rule 11 agreement as we read it into the record, if the court would like to see that. But this is the order that Mr. Mims had prepared and submitted, which was the one that we wanted to get signed. As you can see within the motion for judgment nunc pro tunc, he's signed off on this as well. And that is
I was just concerned with some of the wording on it, but I'll go ahead and sign it now. I'm gonna. Okay, let's see. Okay, I just signed it. And I'm going to email my clerk to make sure she gets it.
Okay, well, thank you so much, Judge. I appreciate that.
No problem. So that's it for today. And if there's any issues with that, just call the clerks, but I have signed it.
Thank you, Judge. I appreciate it. Have a good day.
No problem. Okay, I think our next case is another scheduling conference. Anyone else here on the scheduling conference docket?
Yes, Your Honor. Good morning. Matt Sparks for the plaintiff, Jim Knox.
And Your Honor, Bruce Alford on behalf of the defendant, Steve Noose. I
All right,
apologize. I was on my way down to the court because I was out of town, didn't get the Zoom link. So I apologize. I'm in my car.
No worries, no worries. Sorry about that if you didn't get it in
Oh,
time.
no problem. No problem.
So what's going on with this one, guys?
Judge, actually, if we could just reset this, 30 days out or something, I think we're going to be able to get you an agreed order. If not by the end of today, certainly by the end of the week.
What I do on these is I just need to get a trial setting from you. You guys can submit the scheduling order whenever you want, but we need to agree on a trial setting. So when do you all want to set this?
I'd say 6 months from now would be good from my side.
That should work for me.
So what month are you thinking?
May?
May?
Yes, Judge.
Okay.
Yeah, as long as it's early May, because I have conflicts after about May. What about late April? Would that work, Judge and Matthew?
It's fine by me.
April 26th.
It works for me.
I believe that works. Let me check real quickly. April 26. Yes, that works for me, Judge.
Okay, we'll go ahead and set it for trial on April 26th. And just get the scheduling order in whenever you can that corresponds with that date. And you guys have the great rest of your day, okay?
Okay.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Have a good day.
Bye.
Okay, so let me just double check something here. Oops. All right, so we good to see you. Our next hearing's at 11 o'clock, so you have a break until 11.
Okay.